Over to Ananya. A very good evening to one and all present here. Respected Madam, Sir, and the board members who are here, including the student coordinators. Now I request Ananya N to take over from me and welcome ma'am formally. Over to you.
Good evening, everyone. I, Ananya, a final year BBLLB student in JSS Law College Autonomous, deem it a great privilege to welcome and introduce the resource person of this day 5 of this 10-day capacity building program on ADR, Legal Aid and Allied Laws, jointly organized by JSS Law College and Pro Bono Initiative. Today, we are privileged to have with us a remarkable resource person whose academic and professional journey speaks volume to her dedication and expertise. It is my honor to welcome and introduce Ms. Akansha Singh. Ma'am holds an LLM from the National Law School of India, University, Bengaluru, and a BBLLB honors from Guru Gobind Singh, Indraprastha University, New Delhi. She has also completed a diploma in cyber law from the Government Law College, Mumbai. Ma'am has served as assistant professor at reputed institutions, including Presidency University, Bengaluru, Bharati Vidyapita Institute of Management and Research, New Delhi, Symbiosis Law School, Pune, and Lloyd Law College, Greater Noida. Currently, ma'am is associated with Live Law Academy as a faculty and mentor. Her areas of interest include interpretation of statutes, property law, and the law of contracts. Ma'am has also delivered numerous guest lectures and judged national level competitions like the Herbert Smith Freehills NLUD International Negotiation Competition and the Brown Mostein International Client Counseling Competition. Ma'am has several publications to her credit in reputed journals and has also presented on topics ranging from data privacy to green trade policies. Her academic excellence is matched by her commitment to legal education and outreach, making her an ideal guide for today's session. We're truly honored to have ma'am with us this evening. Thank you.
Welcome, ma'am. Welcome, Kalpesh sir. Over to you, ma'am.
Thank you so much, Ananya, for that more than generous introduction. So I will begin today's session. Good evening to everybody in the audience. Before I begin, I will ask you a few questions wherein I would request all of you to participate. Okay, so maybe you can raise your hand from your devices. I will get an idea as to what all are you aware of. So how many of you, while reading any subject, has heard of intention of legislature? From the boardroom also I can see people. So have you ever heard of this term intention of legislature?
Yes, ma'am.
Yes. Okay, great. Then comes that how many of you have ever read any judgment in its entirety? Not related to ADR, anything from constitution or any subject of your choice. You have read a judgment in its entirety. Because we fear, right? We apprehend. I was also a student at one point, and this was an apprehension for me as well as to this is such a tedious task and how do we really do it? So what I'll do today is I'll keep a mixture of taking you through one judgment from where we are starting today's discussion. I will show you the judgment from 2010 to 2025 for you to get an idea as to how judiciary is interpreting ADR or mechanisms related to ADR. Then we will switch to different cases to understand the judicial mindset and the judicial interpretation. Okay, all these are judgments specific and related to ADR itself, different mechanisms of ADR. Okay, so I will start now with the first case here. That is the AFCON case. So if you have heard of this case, is my screen visible? If one of you can just confirm. Yes, is my screen visible?
Yes, yes.
Okay.
Yes.
So this is a case from 2010 wherein you will see, just a second. It's not visible to me now. Yes. So we see from 2010 that this was one of the primary case. It has not been overruled, wherein we see a lot of judgments related to arbitration specifically continuously get overruled or have certain substitution or changes referred. This one case in its essence has been continued, has been followed. This tells us about the story. So let me ask you a question. You apply your mind and tell me what do you think should happen here. Okay, I will ease this for you. Let's say in a given situation, there are two parties. Both the parties here have not put an arbitration clause in their contract. And now when they reach, the plaintiff and defendant reach to the court, The plaintiff now files an application for ADR. The plaintiff says that I am interested in going for or opting for ADR, and the defendant is neglecting the same. The defendant is not okay about the idea of opting for ADR. Now, do you think the trial court in such a situation should immediately send the parties for ADR, should make up their mind to send the parties for ADR when one party is negating of the same? What do you think should happen? You've been attending so many lectures on ADR now from last 4 days. So any guesses that you would want to make? Yes. Should we be sending these parties for ADR if you are a trial court judge? And here I specifically talk about a situation where there is no arbitration clause in the agreement. So there are two set of laws that we understand. One wherein there is arbitration clause mentioned under the Arbitration Act. You are either you're going to invoke the clause and opt for arbitration. If you do not do so, the party can reach to the court and ask for arbitration to be, the parties to be referred for arbitration. The other way here is where the contract specifically did not disclose any arbitration agreement. Now, in that situation comes the role of the court with regards to Section 89. Yes, somebody has written no arbitration agreement is necessary and mandatory. Absolutely. So this is mandatory. But there is also a provision related to Section 89 of CPC, which tells us something. Okay. Now, this case is basically related to this provision itself. So we will just glance through what all is there in Section 89. Okay. And you will see how the judges have applied their minds, and then they have had that, the consensus of party is going to be the essence in this situation, as well as the situation wherein I show you a judgment from 2025 as well. So in this case, the court specifically, this has a lot of layers to it. Okay, it does talk about the loophole that existed in the language of Section 89. That is why I would request all of you that you start getting into the practice of reading judgments. Now you're in final year, somebody who introduced me, right? And there are other people also. So for you to excel better, you read it in its entirety. And I will give you a very small teaser right now itself. So here there are multiple layers of this case. First, when we talk about Section 89, the judgment starts and mentions the Section 89 as it is. Then it tells that what are the loopholes in it. So one of the loophole was with regard to reading of the term mediation and judicial settlement. It is by this judgment that you see they have said, and the court has clarified that mediation here is to be put in the place of judicial settlement because of the error in the legislative language. Okay, so one is that aspect. The other is with regards to the question that we are understanding, that is it mandatory for the court to send the parties for arbitration. Now the point comes that why has this confusion come at the first place? So if you refer to Order 10, Rule 1A, 1B, 1C of CPC, these are complementary to Section 89. Okay, I will just repeat it again for you. Section 89 of CPC read with Order 10, Rule 1A, 1B and 1C. All of these are complementary to all the different ADR processes. And here, there was a change in language. Okay, now you try to understand what language are we talking about. Where it appears to the court that there exist elements of a settlement. So now first mandate is that for the court, it must appear to them that there exists an element of settlement, okay, by any of the 5 ways of the ADR. Then we say that which is acceptable to the parties. Now, the point here is if you merely go by literal interpretation, right, as judiciary, the primary role is that you read the law as it is, and if reading it in the plenary manner, in the most simplest manner, no ambiguity arises, you do not have to go ahead. Okay, I'll show you one of the quotations also put here in this judgment, wherein they say that if the legislature has said something, the judiciary should not be overruling it. So that is why I asked you in the beginning, what is the relevance of intention of legislature? And this applies in every subject that you study. So if we only stick to this part, we will understand that because both of the parties were not acceptable, this entire discussion would not have been relevant at all if we stick to the plenary meaning. But there is something else also. The court shall formulate. Now the term that is mentioned here is shall formulate the terms of settlement and give them to the parties for their observation. And after receiving the observation of the party, the court may reformulate the term of possible settlement. So what this section was basically telling, and this is still the language, okay? So it is only and only by way of judicial interpretation, we have tried to actually put it into execution rather than sticking to the actual term that is still mentioned in CPC. Now, the judiciary has said here that if we go by the rigid meaning or the plenary meaning that Akansha ma'am is telling right now, the court will have to do something. They will first formulate the terms of settlement. The terms of settlement will come into picture after you have heard the parties, after you have heard whether they have any arguments to make, whether they are denying anything or not. You may take the evidences also, and then you may formulate the terms of settlement. So this is a tedious process. Then it says give it to the parties. The parties will then think about whether the terms of settlement are okay or not, return it to the court, and then now the court will refer you to ADR. Do you think the idea of any law, Mediation Act now, Arbitration Act, is basically this? No. So if we actually stick to the plain reading of Section 89, it will defy the purpose of ADR. That is why from AFCON judgment, the courts have now clarified that here the judiciary does not have to write down the terms of settlement, and rather they merely have to give you a summary of dispute. So this is something which we have interpreted by way of judicial interpretation. Okay, so this is the first aspect as to how do we read it. Then I highlighted on the point shall. If the court has to do this exercise, we have clarified that this will be substituted. Then it says the court may formulate these terms and refer the parties for any of the ADR. The court may. And the question that we began with is whether it is mandatory for the court to send the parties for arbitration or not. So again here, the court has read Section 89. This idea of reading may, along with the language used in Order 10, Rule 1A. Now, what is the language mentioned here? This says the court shall direct the parties to the suit to opt for either of the settlement. Now, the judiciary started discussing and finding a conflict that one provision says that you may refer the party for ADR. The other provision says that you shall mandatorily ask the parties to opt for ADR. So here again, by way of judicial interpretation, the court has provided clarity that first, Section 89 is basically telling you that the first idea where there is no arbitration agreement, the judiciary will do what? They will prepare a summary of dispute. And after this, they will ask the parties whether you want to opt for any of the ADRs or not. The party has the liberty to accept or to deny for the same. So from these discussions, all of this has been clarified by the judicial interpretation. So today's discussion that we have with respect to judicial trend of ADR, from this, we are understanding and getting an idea that all of this has been, and I'm telling you again, this has not been changed. Okay, we made changes in Section 89 after the introduction of Mediation Act. This was removed also for a brief period of time when we introduced Arbitration Act 1940. But later again, we put it back. Section 89 was brought back by the 1996 Act. Okay, so all of these have been made, no change in the language has been made, but yet we understand in essence, the judicial interpretation taken in AFCON case has continued. Okay, so if you will read the judgment, I've given you a summary of this, but if you read the judgment, you will find very great points. So for example, it says that if the literal meaning of Section 89, as we see from the essence, if we start doing it, it is going to be a lengthy process. And that is going to be a nightmare for the judges, for the trial court judges who will have to do this exercise. Then if we actually start seeing it in a literal manner, it may look like you have put the cart before the horse. So all of these things that they are mentioning here is that they have tried to balance and that they have tried to put clarity as to how do we really see Section 89 along with Arbitration Act and other laws. Okay, I am not, because we have paucity of time and we have passed 15 minutes. So maybe I will now go to the 2025 case to show you how the same set of ideology, maybe for a different case, different set of facts, but it has continued to be the same. Okay, these were the primary or the key issues related to this particular case, but definitely there are more points to be read from the judgment, which you can definitely do if you have time. Now I will go to a case which has come now much recently in 2025. Let's see how this case basically talks and discusses the concept of the present law. Okay, so this is the case very recently decided. You can write down the name of the case, that is Mrs. City Corp Finance Limited versus Snehasis Nanda. Now here, the issue is related to a special law, that is Consumer Act, Consumer Protection Act. We have Arbitration Act. And here the parties are basically trying to see, they are reaching to the court to find out whether it is mandatory again for the court to send the parties for arbitration when they are interested. One of the parties interested in going to the Consumer Protection Act. Does anyone know what are the authorities under Consumer Protection Act? Yes. Is anybody aware of the authorities under Consumer Act? And that is also related to ADR or specifically arbitration when we talk about judicial authority, the interpretation of the term judicial authority. So the Consumer Act is a special law, social, beneficial, welfare legislation, and that is how you have to see it. Every law that you read, okay, I would just urge you that you start reading it from their objective, from their preamble, and you will understand the idea of judiciary as to why they are interpreting something in some manner. So here, the first is that under the Consumer Act, we have different commissions, right? District, state, and national level commission. And these are for consumer dispute redressal commissions. Are these judicial authorities? Because we have judicial authority mentioned under Section 8 of the Arbitration Act, which we will now get into when we start reading these cases. So yes, these are also judicial authorities, okay? Yes, yes, very good. Okay, Suman has mentioned here the commissions, all the name of the commission. Very good. Yes. So these are also judicial authority. They are not courts, right? And we have not specifically mentioned the term court in the Arbitration Act because we have clarified that these are also judicial authorities. And from these judicial authorities, we can opt for different bodies. Okay. Yeah, it is a quasi-judicial body, but in context of Arbitration Act, we include it in the term of judicial authority. Okay, that is how I specifically referred that in context of the Arbitration Act. Definitely a quasi-judicial body. Yes. Now let's try to understand that what has happened in this case, in this specific case of City Corp. Yes. So what is, I'll just briefly give you the facts. There are three parties. This is a tripartite agreement wherein they have again not specifically mentioned. The party has not shown consensus with regards to opting for arbitration. But the other party is pushing and saying that I would want to go for arbitration because I have agreed for the same in the contract. So there are three parties, party 1, party 2, party 3. The third party is merely a signatory to this agreement. Okay. And this is basically for security purposes. So in this case, both of them have very vocally agreed on the arbitration agreement. The third party is a signatory, but has not agreed or is now alleging that I did not intend to opt for the arbitration agreement. What will happen in this case? How is the court expected to read this and to interpret this? So let's now try to understand how in 2025, the judiciary is interpreting Arbitration Act, is interpreting what is the idea of opting for or sending the parties for arbitration. So first is, again, I will reiterate the fact that we are here now discussing the role of judiciary in granting arbitration, not granting arbitration, which we have studied in the AFCON's judgment. Now, in this case also, the court here has clarified that the utmost authority lies with the parties only. We understand that one of the party is a signatory, but merely because they are a signatory, it does not become binding on them. If there is an exclusion, we will read the contract in its entirety. We will try to find the intention of the party and then only compel them to opt for arbitration. So accordingly, in this case also, if you read from the language that has been used here, referring to a previous case, one is with regards to that we have to see what is the nature of the dispute. Now, if you start seeing that what all cases are excluded from arbitration, this is very ambiguously put in the Arbitration Act under Section 34. But we have great judgment, like Vidya Drolia is there, right, wherein we have put clarity as to what should be excluded specifically from the arbitration. For example, if it involves probate, okay, or if it involves something which has a right in rem, copyright, or any matter of that sort, all of these are excluded from the ambit of Arbitration Act. So that is what they are telling you here, that the exclusion has to be seen. Whether we will send the party for arbitration or not, the judiciary has to see the nature of the dispute, the party to the dispute, and then only send them for the arbitration to be done there. Now, if you have ever studied Arbitration Act, you must have read or you must have come across this term of public policy. I've highlighted it here and I will cover it now subsequently. That the judicial trend, if you start seeing that how, because we have made so many changes in the Arbitration Act, and we see that all these changes in some way or the other have been with an idea to push the judiciary out or to lessen the judicial intervention. But that again comes back into picture when you put in the law terms like public policy. What is public policy? Now in 2016, we did make certain changes. 2015, it was introduced. 2016, it was added. That we did put an explanation in section 34 with regards to explaining the term public policy. Despite of that, there have been so many cases, so many discussions, interpretation that continues to be there for the term public policy. And that is how we have to ensure the balance, right? When we say that we have to lessen the judicial intervention, at the same time, we also have to see the idea of the law before we push for the same. Okay. So the judges have here, then in this case specifically, because there is Consumer Act, when you go for consumer remedy under consumer law, you understand that you're going under a private forum, right? But under a public forum, wherein you understand that the parties will be exposed and there will be other things that can happen. But in arbitration, it is a private fora wherein the parties will be deciding on a lot of matters, and there can be, they can omit the way of the procedural aspects as well. And that is how, when we compare all of this, then the judiciary in the end has concluded that nothing goes beyond the exclusive choice of the consumer. Again, I'm telling you that from 2010, you see the same depiction happening here in 2015 also, that we have reiterated on the same. The judiciary has continued, maybe in different aspects, but has continued to promote the idea or the essence or the object of sending the parties only and only when they have an exclusive choice, or when they both the parties with their consensus decide on the same aspect. Okay. So this is the first leg of our discussion, wherein I wanted you to see the judicial trend with respect to sending the parties for arbitration, no matter arbitration or other ways of ADR. So AFCON covers all the different type of ADRs, and this case specifically was related to consumer law and ADR. Okay, does anybody has any doubt? Or maybe we can take it in the second half, right, when we conclude. Now, after this, we come to the discussion on judiciary's opinion on judicial intervention. So this is very interesting. I'll just highlight one point to you, that now in the present context, if you see, a lot of cases wherein judiciary has started invoking, and specifically the Supreme Court, the Honorable Supreme Court, has started invoking their inherent power to pass on certain orders, to give certain judgments. So for example, when we talk about the order of remission, okay, we'll discuss that also, mentioned under section 34(4). You will see that there are remissions that have been done, but these have been done not by the virtue of the powers mentioned in the Arbitration Act, and rather by invoking the power under Article 142 of the Indian Constitution. So this becomes very special for us to understand that how has judiciary opined on judicial intervention. When the legislature has specifically put certain sections that you see over here, very specifically put under the law, to promote that we have to lessen judicial intervention, but how is judiciary tried to, still go ahead with it, wherein they feel that there is ambiguity, wherein they feel that there is need for their intervention, they have accordingly interpreted a lot of aspects. So we will now understand the judicial direction and the judicial trend with respect to their own judicial intervention, which is related to all these provisions. So specifically, if you refer to Section 5. I'll give you a brief idea of this. If you have your Bear Act, you can refer to your Bear Act along with me when I speak of it. Okay. So first is Section 5 of the Arbitration Act, wherein we understand that very specifically it starts with a non-obstante clause. It says notwithstanding anything in any other law. So arbitration law has very clearly put forward that if these are matters governed, the judicial authority shall not intervene. So wheresoever the intervention has been allowed, the judiciary can intervene only in those situations and not beyond that. Okay, so Section 5 specifically gives the reading of the mind of the legislature with regards to circumscribing the aspect of judicial intervention. Okay, that is Section 5. Then next we have mentioned Section 8, again wherein we have to go for the appointment of the arbitrator. Okay, so when the power to refer the parties for arbitration. So Section 8 also specifically says that when the court is reached by the parties, they shall refer the parties for arbitration. So this also again gives a very clear idea. Now we will discuss all the judicial terms and how these have been interpreted. Right now, first and foremost, I am introducing you to these provisions. Okay, then I will tell you how judicial intervention and how judicial interpretation has been done on reading of these plain sections. So for example, when we talk about Section 8, do we need judiciary to intervene here? But they have done to provide clarity. The simplest example, because this uses the term judicial authority, the court had to come and in a lot of cases, the different high courts and the Honorable Supreme Court has tried to give clarification as to whether this body is a judicial authority or not. So you require, and that is how the balance is to be made, and that is how we have to see that if this has certain ambiguities, that has to be addressed by the court in the given situation. Okay, so Section 8 also specifically mentions that a judicial authority has to refer the parties for arbitration merely on the basis of the prima facie existence of the arbitration agreement. So again, you do not have to, for referring the parties, you do not have to get into the validity or the existence of the arbitration agreement, rather only whether the prima facie from the terms you feel that the arbitration agreement exists or not. The next section that I have mentioned is 29A. So 29A basically talks about that there is a time limit. I believe it was addressed also in yesterday's class, that what is the time limit for disposal of any matter before the arbitral tribunal. So it is 12 months, which can be extended by 6 months with consent of the party. And then again, you bring the concept of court. We say that you can reach to the court for a more extension. And mind it, there is no time limit mentioned here. So if the judiciary feels, and this again has been mindfully interpreted by the judiciary, that if they feel there is requirement, they can give you extension of time beyond this 12 plus 6 months. So again, the scope of reading of judicial power and their intervention. Okay, then Section 34 and 37. So 34 is a very long provision which has multiple aspects for its interpretation. So we will get here and we will now see how judiciary has interpreted all these provisions, and we will try to understand it in context of the given situation. Okay, now let's go to our discussion on these aspects and to see Again, the judiciary's opinion on judicial intervention. So that is how I have tried to formulate it, and we see it from different judgments. So first is, we start with the Videocon case. Here we are first talking about that the term judicial authority. So the court here clarifies and has put into aspect that judicial authority is a very wide term. We very mindfully did not opt for using the term court here, because from all these aspects, whenever you are reaching, let's say X and Y have met into a dispute, okay, the plaintiff wants to go for remedy under Consumer Act. So can now this body also refer you for arbitration when they see that there is an arbitration agreement? Yes, they can do so. So that is the reasoning which was mentioned in the law, and this is how the judiciary has tried to interpret it in this case. Secondly, they talk about the role played by the judiciary. Now, this is not specifically mentioned, because this understand that there are limitations of the law, right? When we make the law, and I'm not able to recall, but in one of the landmark cases, it has been said that when we make the law, we cannot actually foresee and expect what all is going to come in future. So accordingly, the law was made. But what is the role of judiciary in under Section 8? It has been clarified with this case. They say that the role played by the judiciary while exercising the power under Section 8 is more of administrative rather than the conventional judicial one. So they do not act as an adjudicator. Now, how do we understand? Because they very specifically say that if you see that there is a prima facie existence of arbitration, you can immediately refer the parties, okay? So you do not have to adjudicate, you rather only and only have to perform certain administrative framework, administrative function throughout these powers which are given under different laws. For example, under Section 9 also, there are certain power of interim relief to be granted. Again, you are one way you are saying do not go to the court, and now you have put Section 9 wherein you say that for these interim relief you go to the court. So again, by way of judgment, the courts have clarified that this has to be seen as an administrative function, and the judiciary will not be intervening with the power of the arbitral tribunal. Okay, so this is one judgment from which we understand that what should be the role of the judiciary while dealing with these cases. Another one wherein they have said that the power is to be exercised only and only with respect to the judicial conscience. Okay. And despite of all these laws, these judgments that we see, we still find that a lot of superfluous judicial intervention exists. And if you're aware of the Gayatri Valaswamy judgment also that is pending, we will get a lot of clarity with respect to the working of Section 34, which targets on the concept of judicial intervention. So had that judgment come, maybe I would have picked that itself as our discussion. But when you read it, keep all these points in mind when you read that case, whenever the judgment comes, with regards to the idea of judiciary and with regards to how we are making changes. All of these are intertwined. I have shown you so many sections, Section 8, 9, 5, 11. We talk about 29A, 34, 36, 37. These are all intertwined and are based on this particular principle or idea. Okay. Then this is not just the Indian courts that are saying so. We have English judgments also, which specifically have clarified with respect to the interpretation of the term judicial authority. So the Indian courts here, and when you read these judgments, you will find mention of these precedents. Okay, from adding as an external aid, the courts have here referred to these cases and mentioned that yes, we understand that long back in time when the English courts in 1909, 1931, the idea of their judicial authority, using the term judicial authority, is as simple as ours, which is extension of the judicial body beyond the using of only the judges in the system. Okay. Now, as I told you about Section 9, again, from this judgment, it is very clear that when we started, when we started reading Section 9, the problem arose is that this is giving back the power to the courts. And therefore, in this case, the court reiterated on the fact that scope of Section 9 is to only enable the arbitral proceedings to go ahead. Okay, and let's say the arbitral proceeding is related to a particular subject matter, which is a particular immovable property. Now if you want injunction on that, you can go to a court, a civil court, by virtue of section 9, and this will do what? The civil court's power of granting you interim relief will be to smooth the glide of arbitral proceeding. So that is how the judges have clarified that here, when we are exercising this power, we have to keep this in mind, that there is a prima facie need, there will be irreparable loss, and also to compare the mischief. If I allow this interim measure or if I do not allow this interim measure, what will be the mischief that will happen to either of the party, and then bring balance between them. Okay, so this is how we read section 9 also. And again, this is not something from the law, this is again something reiterated or that has come by way of judgments itself. Then we go to section 34. Now here you will see majority of the cases, whatever cases that you refer to, Hakim, you refer to Vidya Drolia, you will see that it has something related to section 34. And I will tell you why section 34. So if you have ever referred to the law, I've put a summary over here. Section 34, first and foremost, is this related to appeal? You can refer to your copy of section 34 and then answer, do you think the idea of section 34 is to provide you a forum of appeal? The title says application for setting aside arbitral award. Yes. From reading of the title, or I will read it out for you. It says application for setting aside arbitral award. So yes, the primary idea that we get and people started getting was that this is one of the venues by which you can, if you're not happy with the arbitral award, you can go and get it challenged here, or you can go into the appeal under section 34. So now the judiciary has clarified this is not a provision which allows appeal. Here specifically referring to the power that is so mentioned, this is where the courts can only and only set aside the award granted. They can set aside, they can remit it back to the AT again and say that, okay, you see, and I will tell you what is the scope of remission and all. So do not get confused and understand that the idea, the primary idea of section 34 is not appeal, but rather merely a very limited power of setting aside of an arbitral award. How the setting aside has to be done? This has to be done on certain given situations. Okay, the situations have been mentioned here, but these are so mentioned that they leave a scope of interpretation. And again comes the role of judiciary, again comes the role of judgments that we are studying and we are referring to. So let's understand what are these different aspects. So section 34, I put a summary over here. Let's say the party was under some incapacity. So let me just tell you, we understand incapacity as legal incapacity, mental incapacity, right? But there are judgments which have clarified that if in a given situation you did not provide notice to the other party, they did not get the window for them to represent themselves, and we know that it is a mandate that you allow the party to represent themselves. So in that situation, that this can also fall under incapacity. Now, how has this come into picture? Only and only by way of judicial interpretation. Okay, so the judicial trend with regards to reading of 34 also sees a wave in the interpretation. We have certain provisions that are mentioned here, but there is definitely scope of interpreting these as well. And that is what has been done here. Okay, the agreement is not valid in accordance with law. So this can anyone think of anything? The arbitration agreement is not valid in accordance with law. In accordance with law. So you read this law in your first year of law college itself. This is the Contract Act. Let's say this is also a contract, right? So it is not valid because it is vitiated by undue influence. So that will also fall here under section 34 itself. Now, all of this is still good. The problem comes when we come to the idea of section 34 2B, wherein we mention that the arbitral award is in conflict with public policy of India. Now, public policy of India, as I told you, it massively initiated so many judgments wherein one judge would say public policy means that something is immoral. Public policy would mean that something is against the idea of development of the country, right? So very open-ended term that we see here, and that is how you see the judicial trend now. So Dyna Technologies, whether we talk about recent cases or we talk about very old cases, these concept of public policy has been reiterated and has been explained in different manner. So I will now tell you these two cases that are there wherein public policy was explained, and these have been dealt before the 2015 explanation that we have added. I am presuming and I'm believing that all of you have the hard copy of your BER Act. There's paucity of time, otherwise I had the copy, but if I keep fiddling from one document to another, it may eat up our time. So please refer to your copy. You can just Google now also. If you see, we added an explanation in section 34 2B, 34.2 with in 2016, and this explanation has been motivated by these judgments that you see over here. Okay, so the present explanation says that something is against public policy if the making of the award was induced or was affected by fraud, corruption, was in violation of these sections, is in contravention with fundamental policy of Indian law, is in conflict with the most basic notions of morality or justice. Now tell me something. We started our train, okay, or we started our journey saying that we want to put clarity to the term public policy. And then you put terms like morality and justice. Are you really doing the job right? But the other way of the argument will be that is it really possible for us to define the term public policy? So when these cases like Renu Sagar or the saw pipes case, ONGC saw pipes case were being discussed, the court had the notion, or they started talking about, that public policy is an unruly horse, which you see in your contract law classes also, wherein we say use the same statement that public policy is an unruly horse. That means that it can that the person who's interpreting it will have so much of power as to how they want to interpret that term. But on the contrary, it has been said, and now has been, it is to be seen that it is not an unruly horse, and rather we have tried to put certain embargoes, which is justice and morality, which is what interests India, which is fundamental policy of Indian law. So there are two leg of arguments, but the idea here is that the explanation or the amendment was made because of the judicial trend that we see in these cases like ONGC and Renu Sagar. So here they mention that public policy can be understood as this, and this is what we have continued to do so. There was also one of the aspect of talking about patent illegality. Now, what really happens is right now you're studying law. After 1, 2, 3 years, you will be graduates, and then you will start criticizing what is written in the law, right? And that is our job. So as lawyers, then you will, some may pitch that we have to put back patent illegality. Some may say that no, patent illegality was not right. So there was basically in the Renu Sagar case, we see that there was a provision which was recommended by the judiciary, that if something appears to be patently illegal, we can consider and say that this is against public policy. But patent illegality again is a very stricter term, is a very narrow term, which should not be considered, or we should not be equivalent to public policy. So that is how you see that from a narrow interpretation we move to a broader interpretation, and then again we have now tried to narrow down the concept of public policy. Does anyone know why in the present law we have tried to narrow down the concept of public policy? You can just use your brains and immediately think of it, okay? That why do you think these trends that I'm telling you about, Renu Sagar, ONGC, and then ultimately the present explanation of public policy is in a narrow manner? Why the narrow definition has been opted for? Yes, any idea?
There's an answer from the courtroom.
Yes, please, ma'am. Yes.
I think it's because the intention of the legislature is to limit the grounds of judicial intervention when it comes to.
Yes, perfect. Yes, exactly. The idea or the objective of law, again, I told you all of these are intertwined. So when we refer to the idea of law is that section 34 is providing you certain windows. And again, by judicial intervention, very specifically, we understand that all of these are exhaustive grounds, correct? Also because it does not use the term includes. So it very specifically says an arbitral award may be set aside by the court only if they would have written the term includes on these ground, which includes this, the idea of the legislature would have been opposite. But as we got the answer from the boardroom, this is in consonance with the idea that the judicial intervention has to be circumscribed, it has to be narrowed down, and accordingly, public policy also has to be seen in a stricter manner. Only and only in certain given situation you allow for it to be set aside by the court. Okay, so that is absolutely right. Now we move ahead with I hope this was clear. There are multiple other discussions also, but maybe we'll move ahead with regards to the concept of the judicial activism and judicial intervention. So as I told you, in the present context, when we see a lot of cases, and specifically when I talk about 34.4, so I will take you there now. This basically provides a window for the remission to be done. Let me just open my arbitration. So section 34.4, if we refer, it is again saying that if the judiciary is reached out by the parties in a given situation, the motive of the judiciary should be what? To ensure that they are promoting ADR, at the same time to ensure that they do not intervene beyond the allowed limit. So this is a depiction, and this, even though there is a lot of clarity, there is also a lot of ambiguity in this, which we are expecting now, in the coming judgment, that we will get more clarity. This basically says on the receipt of an application under subsection 134 that we just referred to, the court may, where it is appropriate and it is so requested by a party, adjourn the proceeding for a period of time determined by it in order to give the AT again an opportunity to resume the arbitral proceeding or to take such other action as in the opinion of the AT will eliminate the ground of setting aside the arbitral award. Now, the concept here is that first, they are very, very benevolently put here that if you feel that there is, let's say, there is something which can be cured by the arbitrator, again send it back to the AT and tell them to fix it. Okay, and something very similar exists in section 33 also, wherein we see that if there is merely mathematical clerical errors, then also you can do this exercise. But here the grounds are not mentioned, and this party is coming to you challenging the arbitral award. And you have to understand that the idea here is that we do not allow the same. So we see the conflict here arises with respect to first, that what are these grounds? If that arbitral tribunal was the one which was defaulting in doing something, now you are allowing the parties to go back to them. And Dyna Technology is one such case. We have M. Hakim, wherein you see that the court has been hesitant. And you also see on the contrary that there are a lot of cases wherein the court uses the power of 142 and says, I'm sending them back for remission. So is this really a right way? Is this really that how the judicial trend should be moving forward? Or rather we need clarity on the same. So that is why first, that you have to believe and you have to understand that a party who is reaching to you is coming to you because this arbitral tribunal has given an order which is patently illegal, or has given an order which is against public policy, and now you are again sending me back to the same AT. Again, I will maybe most likely I'll come back to you. This will be an elongated process, and this is not the intention of the law, right? So therefore, we have to be mindful. The judiciary has to see and to absorb this trend, that they have to be mindful of using this power or the power under section 151 of CPC, Again, an inherent power. Again, we see so many times have been used by 34. So courts have clarified that 34's power is not equivalent to the power of mentioned under section 151 of CPC, that is an inherent power. This is much more narrower in nature, and accordingly it has to be perceived, and accordingly it should be seen as well. Okay. Then we have section 36 and 37 as well, wherein you see that for enforcement, again you go back to the court, and again there are judgments which say that how it has to be executed or how it has to be seen in a given context. Okay, so I hope you got benefited. I hope I have at least given you certain clarity with regards to how the judicial intervention, how judicial interpretation has been, starting from AFCON case, wherein I intended to finish the entire case with you. I wanted to take you through the copy of the judgment, but keeping time in mind, I have again left this on you that if possible, read this case. You will understand the nuances as to how wide the power of the court is when they are discussing. But at the same time, you have to keep in mind, no matter which judgment that I have referred to in today's class, every aspect, every case, you will see that the judiciary's intervention is to be in coherence with the idea of the law and to promote ADR mechanisms, whatever it may be. And accordingly, we see that AFCON is the best possible way for us to see the intention, wherein we have put clarity, wherein we have put, when we say, let's say section 5, which puts a non-obstante clause, and on the other side we have section 89. So we have to balance, and that is how we see that section 89 has to be read in a manner that it complements section 5 of the Arbitration Act or of the other laws as well. Okay, yes. So with this, I will conclude. Now you can ask your doubts.
Yes, sir. Yeah.
Unmute
So
and
participant, yeah, please. Participant, any question query from your side, or you can raise your hand, unmute yourself, or can put up a question in the chat box.
there's a question in the chat box.
Yes, I can read it. I'll just read it. Yes. So if you see, we have section 9 and then we have section 16 also. Okay. The idea here is that's what I was telling you. When you read section 9, you will get an idea that why are we sending the parties back to the court? But that is to promote the arbitral proceeding. I gave you a simplest example. If you do not grant injunction right now, the party may dispose of the property. And therefore, for this to be done, it is preferable that you and section 9 is much more wider than the power under section 16, because section 9 can be invoked before the arbitral tribunal is set up also. Okay, so that is where you see that here we are promoting and we complementing the concept of ADR arbitration specifically, and that is why it has been kept intact. Should India adopt for a stricter non-intervention policy to make arbitration-friendly jurisdiction? Definitely. Now, if you see, this was in news, right, with regards to the Singapore jurisdiction saying that the entire arbitration that was decided by one of the ex-justices, Supreme Court, was not right. So we have to, at the same time, when we say that we have to have a stricter non-intervention policy, at the same time, we have to promote and we have to keep in mind the idea of arbitration within the country has to be first protected, has to be seen. And that, I think, primarily will come when we have more clarity in the law. Because today, one court, and this is the biggest power that you will see, one court has decided on something which gets overruled by the other court. So I understand this is subject to interpretation, but at the same time, this being a new law, considered to be a new law, though it was introduced in 1996, 1940, in fact, but still we have to put more clarity on the same. And I did work with the ministry right now with the bill, the present bill, and I'll give you an idea that I'll give you a brief about it, that despite of our best efforts, there is a lot of neglect and a lot of non-liking by majority of the people in practice. They do not appreciate the introduction or the changes that we have tried to make in the new bill. So that has to be done by experts. It has to be kept in mind, and accordingly, by promoting first domestic arbitration, maybe we can invite the other jurisdictions also. Yes. Thank you.
Ma'am, there's a question from the boardroom.
Yes, please.
What is the binding of judicial intervention when it comes to international commercial arbitration?
So understand this. It is a lengthy discussion when we talk about it. When we talk about international arbitration per se or their awards, the Indian judiciary has in some way or the other shown reluctance. Okay, they do not generally opt for overruling of the same, and which I think is preferable also, unless and until you see that there is patent illegality, unless and until you see it goes against the idea of the Indian law at all. Absolutely. Unless that exists, I think it is absolutely fine, and the judicial trend has been to promote these such of practices. Yes. Any other question? How many of you were able to understand? Because I think I did go a little fast. I wanted to give this a caveat in the beginning itself, but were you able to understand? Some of you at least?
Yes, ma'am.
Yes,
Okay.
ma'am.
All right, great.
Yes,
Ma'am,
any other
on
question,
another
participants from boardroom?
Ma'am, on another note, can you give us some tips on how we should be looking at a judgment or how we should be reading it?
This will be my favorite part of today's class. Okay, I'll tell you, because this is mostly what I do. So I'll be honest with you. Long back in time, there was a phase where I apprehended. If somebody would tell me that I've read 1,000 pages of judgment, I would be like, how have you done that? How is that practically possible? But I'll tell you, this comes with practice. Okay, I've been told this, but I'd never believed in it. You do one thing, you pick any 10 judgments which are not very lengthy, 10 to 12 pages of your area of interest. Pick the recent ones which you can find on any of Supreme Court's website, any other website. Just read them once without keeping any apprehension in your mind whether I'll understand this or I will not understand it. After you're done with reading 10 judgments, you will get to know that there is a structure that they follow. In some cases, you will find a table is mentioned, and the table, if you click on any of the concept, it will take you to that page. Okay. So in some cases, they simply put a table. It gives you an idea as to understand the structure. No matter whether you talk about electoral bond, you talk about any other previous judgment, okay, from the previous year, almost most of the landmark ones have that table. First thing. So you will get the structure, keep that structure in mind and read each paragraph, read each point. This will help you understand each concept, no matter which law you're talking about. So one is that. Second, after you're done reading these 10 judgments, you will know what is to be read. For example, there can be, that the party has now come to the Supreme Court, they went to the trial court, they went to the High Court, and now they've come to the Supreme Court. So those facts will also be mentioned there in the judgment. If you're practicing, if you're going to take it up as one of the precedents when you're going to the court, you need to understand each and every fact. If you're a researcher, maybe you can omit on a lot of details. But if you're practicing, again, I'm asserting on this fact that every date, every aspect is going to matter to you. If let's say you're preparing for judiciary, your problem-based questions, or how you see any question which has a lot of facts in it, it is a replica of a judgment. If let's say I am telling you that you and I enter into an arbitration agreement today, and now the breach occurs after 1 year, and you go to the court after 1.5 years. All these dates become very, very relevant to understand the conduct of the party. So when you read a judgment, this will not come immediately, but maybe gradually with time, that you will start identifying that I have to know what is the nature of the goods that they are selling. Simple Contract Act judgment. what is this that they are dealing with? Is this perishable? Is this something that is not available? Is this something which is an essential commodity? Is this something which is excluded, for which an arbitration cannot be done? So these are facts that you have to highlight, you have to understand from the judgment. Then the most and the place, no matter which case you talk about, you will see something related to interpretation there. And interpretation was not my area, it was not my subject, but this has come eventually and gradually by reading judgments, wherein I see that the simplest way of cracking the code is to see which principle have they opted for. So AFCON judgment specifically refers to two rules: mischief rule and the purposive rule of interpretation. Why is this something that you have to specifically study? The minute you read the minute you read the judgment, you will get to know that from today's reading, I've also understood how purposive rule of interpretation is to be applicable. So try to see, identify what has been the idea behind the judiciary opting for or suggesting that this is to be read in this manner or the other manner. So that will be the second point. And third will be, when you come to the set of remedy that is asked, whether they are asking for, and whether there was an interlocutory application that was filed, what was the decision of for this interlocutory application, whether there were certain interim orders that were filed, what was the decision, highlight these points also, because this is something which is going to affect the final reasoning or the final ratio of the judgment. And then in context of this, read the reasoning. What compensation? Why this compensation? Did they go ahead and saying that, the preliminary decree that was so given has been now in consonance with the final decree that has been decided? So this is how you can, divide it into certain aspects and then maybe do a reading for the same. I hope this was sufficient for you.
Thank you, ma'am. Participants, are there any more questions? If there are no more questions, with the permission of ma'am and Kalpesh sir, can we end the program?
Yes, yes. Participant, any last question? Anyone? You can raise your hand. I have unmuted all because there's a disturbance. Anyone? Okay, I think there is no question. Over to boardroom.
Thank you, sir.
Good evening, everyone. As we draw to the conclusion of today's session, it is my privilege and honor to deliver the vote of thanks on behalf of JSS Law College and Pro Bono Initiative. First and foremost, I extend our heartfelt gratitude to our resource person of the day, Ms. Akansha Singh, for taking the time to share her deep knowledge and experience with us. Your engaging session filled with valuable insights has truly enriched our understanding of the topic. I would also like to express our sincere thanks to Dr. Kalpesh Kumar L. Gupta, founder Pro Bono India, for his continued support and collaboration. Thank you, sir. A warm thank you goes to our faculty coordinator, Ms. Asma Tunisa Ji, assistant professor and course teacher at JSS Law College, for her dedication and meticulous planning. Thank you, ma'am. I also wish to extend our gratitude to Professor Nagendra Murthy MP, who is present with us today online, senior faculty member and course teacher, for his constant support and encouragement throughout this initiative. Thank you, sir. Last but certainly not the least, I thank all the participants for your enthusiastic presence and engagement. Once again, thank you all for being part of today's session.
Thank you, ma'am.
Thank you very much, Akansha, and look forward to see you in future. Thank you.
Thank you so much, sir. Thank you to everybody in the boardroom, all the faculty members, and all the students in the audience. Thank you so much.
Thank you.